meeting of licensing. Can we take any apologies?
There's no apologies today.
Okay, thank you. Is there any declarations of interest?
As and when,
Okay. Can we confirm the accuracy of the minutes held in the licensing committee on the 25th of November?
We will do this, Madam Chair.
There's just one query that I had with, although the minutes are accurate, application of the street trading consent. There was no note that members asked questions, and also that there was a representative from Abergavenny Town Council. Would members wish that to be included in the minutes? They were very, although they are accurate, they were very concise.
I wasn't here, Madam Chairman, but could I ask a question? You say that a member of this committee was speaking on behalf of a town council? Did you just say that? Oh, all right, fine.
Perhaps the most appropriate way, Chairman, will be to put in the people present.
Yes, we could do that, but I'm not quite sure that it represents that members were given the chance to ask questions, and also that we had a representation at this committee for from Abergavenny Town Council.
Are you saying it's not a true reflection of the minutes?
No, the minutes are accurate as they stand, but in the addition, that what is not in the minutes is that there's no account in these minutes that actually members asked questions of the applicant, and also that we had a representative from Abergavenny Town Council who also presented. And I'm just wondering that needs to be in an addition to these, which are accurate minutes.
Could I ask another question? And I mentioned I wasn't here anyway. Was there objections agendaed at that meeting in relation to this trading, to this application?
Yes, they were in the report.
In which case, then I think it should have been recorded.
Could we just add what the information you was given to us to these minutes and accept them?
Sorry, David, you say that again?
Could we just add what the information you was giving us then to these minutes and accept the minutes as read, please?
Councillor Powell was here, wasn't she, and spoke quite firmly on there, but I mean it should go under the people present, and she was representing Abergavenny Town Council,
Yes.
not in her
Yes.
capacity.
Yeah.
So that should definitely go in the members present.
Well, yes, we can do that, yes. Yeah. John.
Yes, I concur, Chair. Those present should be listed, and in what capacity? Yes, absolutely. So please add it to the minutes, and we'll agree.
Okay. Do you want to add to, in addition to it, that members were asked questions? No. So we all agree, show of hands, that the minutes are accurate account and with the addition of members present. Did you want? No. Number 4, to consider Draft Licence Act 2003 policy statement, copy attached. Linda, you're going to present this? Yeah.
Okay, the purpose of this report today is usually every 3 years the licensing policy needs to be in place, which is under section 182 of the Licensing Act, of how the authority will process applications under the Licensing Act, which is premises licenses, personal licenses, temporary event notices, and a number of other things like reviews as well of premises licenses. On this occasion, because of changes in legislation, it was changed from 3 years to 5 years. So the report has obviously been delayed slightly. It has to go to full council for it to be approved. But I thought it was pertinent for it to be actually brought here beforehand, before we actually start the process of consultation. And in 3.6 of the report, you'll see the actual flow then of how we intend to sort of get the actual policy through. It has to legally be in place by the 7th of January 2016. However, we've been working on it with Gwent Licensing Forum to actually aim to get it slightly earlier in June 2015. And there is method in that madness, is because at around that time we will have to start work on the gambling policy under the Gambling Act. So you'll start the process of consultation. So we didn't want the two to run together because of the huge amount of work that needs to be done and the in-depth look at both policies. So Gwent Licensing Forum aim to sort of do it in June 2015. But there's also other reasons as why we thought it's best to actually start the process. Now, we've been working on it for a number of months. Is because of a number of changes in legislation, which is highlighted in 3.5 of the report, which has changed the policy quite vastly, really. I've attached the policy today. I've started the consultation process already. That was done just prior to Christmas. It sort of went out. It's gone out to a number of people. It's gone out to all the premises licence holders, all the personal licence holders, for them to actually view it on our website. We didn't send the whole document because it was so big. But they have an option then of actually getting the policy document from us if they wanted a hard copy as well. So it's gone out, as I said, to the police, fire service, all the people who are licence holders, all councillors, all town councillors. I'll also send it, I haven't done it as yet, but I'll also be sending it out to people that tend to act on behalf of premises licence holders, like all the firms of solicitors like TLT, Pops and Allen, the one we normally get with people processing such applications. So they can also have a say in the policy itself. The actual policy is Gwent-wide. There are two differences for two authorities, namely Newport and ourselves, because Newport got a cumulative impact area in the city centre, and we've got a similar thing in Chepstow as well. So the police have requested this is retained. So that's the only difference really in the policy throughout Gwent, is because of those two areas, which is mentioned actually in our policy itself. So it's to give you an overview of it, and for you to have your say within the 3 months period as well, if you want any amendments to the policy. It'll be brought back after the consultation period, and then we'll then decide sort of a final-ish draft before it goes to full council for the actual sort of overall rubber stamping of the document.
Just one thing, Madam Chairman. Would it be appropriate, as we're webcasting this, and we are webcasting, aren't we, for everybody at the top table to introduce themselves to those watching? And the second thing is, could you just confirm that town and community councils have been informed of this? You said councillors, you see, and I'm just wondering if that's what you meant. I'm sure you meant that. Thank you, Linda.
Yes, I'll introduce myself as Linda O'Gorman, the Principal Licensing Officer for Monmouthshire, and that's the reason why I brought the report here today. Yes, I can confirm it is town and community councillors as well. Okay.
Yes, I'm Hugh Owen, Principal Environmental Health Officer.
Okay, Linda Guppy, Chair of the Licensing Committee.
Brian Strong, Vice Chairman of the Licensing Committee.
Nicola Perry, Democratic Services Officer.
Jan Gilly, Solicitor.
Dave Evans, County Councillor for West End Ward in Caldicot.
Jim Higginson, County Councillor for 7 Ward, Caldicot.
Frances Taylor, member for Maygar.
Ralph Chapman, member for Mardy.
John Prosser, member for Priory and Abergavenny.
Councillor Ruth Edwards for Glentilio Cresceni.
Anne Webb, representing Tintern and St Albans.
Martin Hickman, Llanfairpwll Fawr.
Councillor Howarth, Gilwyn, Llanelli, and Clydach.
Okay, Councillor Prosser, did you want to ask a question?
Yes, looking through this report, Chair, it starts off by saying it's a common policy in Gwent, and I think you brought along a few comments which sort of counteracted my question, really, because I was going to say there's specific references in this document, so where does it diverge from being a cross-Gwent document to being a just Monmouthshire document? So that's the first question. Obviously, we've tailored ours a little bit, so how far has the tailoring gone to say it's different to the others? The second one is I found it quite a lengthy document, as I would expect, and so as a member, I'm sort of sitting here thinking, well, I'm endorsing what the officers have put together, really. They're the experts, they're the solicitors, etc., and they've put it together. It is an update of a schedule, of a policy, and it would have been useful to have the differences from last time highlighted so that I could concentrate on those areas which, okay, did we need to change that reference to, or the amount of, from, whatever, and that would be very useful in future to see where the differences do actually lie. Because it is quite an intense document, and really to give it justice you need a full day if members were going to ratify every paragraph of it. You know, you need to go into each paragraph and ask the questions, why, for, has this changed or not, etc. So I think a brief summary of changes would have been useful. But apart from that, I've read it all through. And it runs well. You know, I can understand the psychology behind it all, and I trust the officers that the limits put in there are the appropriate limits that we are used to and what the legislation demands.
If I can answer a few points. I mean, the bits in 3.5 are sort of the major sort of changes, really, compared to the old document itself, which is the changes in legislation. But yeah, take on board, it would have been easier if I'd have said these are the bits that sort of changed. The layout has changed slightly in that we got it in sections rather, so that if there is changes in legislation, we can take out the section to make it easier to come before sort of committee. The profile of Monmouthshire is different, and so the cumulative impact is different. All the rest of the document, obviously referring to sort of Monmouthshire instead of like their council, is exactly the same as has been ratified throughout Gwent. But so the changes, extra bits in there that we had to tweak was the bits in 3.5, the legal changes. But I can go through if it makes it easier and say, well, this is the bits that's changed in whatever paragraphs, and then perhaps sort of do a further report to yourself, throughout the 3 months sort of consultation period.
Yes, Chair, I'm aware that it does come back to this committee, so at that stage, if the summary could be included, that would be useful. Thank you.
Councillor Jim Higgins.
Thank you, Madam Chairman. Yeah, and the point that I see on the final bullet point of 3.5 is this issue has been concerned of many people at a different point, excuse me, at different points in time. And it's the issue of the ban of the sale of alcohol below the cost of duty-free plus VAT. So that's an interesting one in that, supermarkets do tend to push the alcohol at very low prices at different points in time. Promotions, I suppose. But this is an interesting one, and I just wondered, in view of the fact it is there, has there been any comment from the trade on that?
No, because it is quite recent anyway with the VAT. They've tweaked sort of the mandatory conditions with sort of underage sales and promotions, irresponsible promotions. And I think they've just taken it on board that it's not sort of, you've got a price indication you can't sell below a certain price. It is the duty of VAT element on it. So they've taken that on board. So there's been no comments that on this matter at all, really, from the trade.
Thank the officer for that, Madam Chairman. In which case, I mean, I've gone, as indeed Councillor Prosser, I have gone through it as well, and I don't see anything, there's any that I have any objection to in there. And, I mean, and other members, obviously, they want to say what they want to say about it, but I feel it is acceptable to me. Thank you.
Councillor Howard.
Yeah, may I ask just on the early part of the first bullet point there, Linda, reference to the TENS. We all welcome the TENS now. We all have an email, if you can read it sometimes, because it is, and that is a point. Just could we just have a look at that? I see there that it does say there, with objections, the notices is changed to allow late TENS to be submitted between 5 and 9 working days before an event. Reference to the consultation on that then, there is no consultations on it, it's a temporary event notice. Is there anything that we're looking at to make sure that we just, that late aspect of it is tightened up a little bit better?
I can explain, with temporary event notices, there is consultation with environmental health and the police on all temporary event notices, regardless if they're the 10 working days prior to it, the normal temporary event notice, or the late 10s, which is between 5 and 9 days. The difference with the both 10s is if it's the normal temporary event notice of 10 working days, it can be brought back to committee if it's felt the conditions should be put on the temporary event notice by either environmental health or police. If it's a late 10s, they could refuse it outright and there's no right of them coming to committee. So that's where the difference is. You know, so if there's huge objections from the police or environmental health, they haven't got a right to committee at all. Okay.
Yeah, there's a couple of pointers that I wanted to... Sorry, Francis.
Yeah, just one point I wanted to make. In terms of the statutory consultees, I don't see the Health Board, an Iron Bevan University Health Board noted there. I declare an interest. I'm a community member of the board. However, when you look at the risk of harm from alcohol, it's very much focused around the crime and antisocial behaviour element of harm, as opposed to the risk from health. And if you look at the risk registers now for public health, alcohol features exceptionally highly, and there is, I think, probably a discussion to be had between licensing authorities and the Health Board about generally how that works. And I noticed that they're not there, and I wondered why that was, and if they will be consulted.
Public Health will be consulted because they are a responsible authority now, even though they can't actually say, you know, that we've taken on board ourselves and we'll send it out to all the responsible authority, even though it's not a statutory duty, because you can go over and above whatever's there anyway if you feel people need the documents. So Public Health are consulted on that. There is, they are working towards actually bringing in Public Health. It's not in place now at the moment as being sort of the fifth sort of element of objections under the Licensing Act. It's not in place yet, but we do work closely with Public Health with data and analysis from hospitals and various things like that. So we bring it to the responsible authority meetings as well. So we can sort of tie up. It obviously can't be 100% accurate because you could have somebody, say, ambulance picking up outside a premises, and it's not necessarily that that person came from a premises where the harm may have taken place. But we do work closely with Public Health, and they're also getting a copy of this document as well. Yeah, confirm it. There will be a consultee.
It doesn't say specifically, explicitly.
Yeah.
They will be consulted.
But yeah, they will, because they are responsible authority, they will be consulted on this document.
That's very much related to licence
Yeah.
premises, and I think this is wider. This is just generally around the use of alcohol and, you know,
Yeah.
cultural aspects for which the licensing authority has
Yeah, we will be dealing with them because of the fact they have a party to the actual premises licences anyway, so they will be consulted.
There's a question, sorry, I marked it up and my battery's just gone. There was a question, I think it's 3.7, of the licence where it says reasonable, the timing are displayed on the website. Is it reasonable time? Do we need to give an indication of what that reasonable time is and sort of not allow ourselves to be open for criticism?
Sorry, which bit is it?
I think it was 3.7. Page H of the policy. Section 3, 3.7. Page 18. Thank you.
Yeah, that is left quite open. Usually it tends to be within, once a decision has been made, we usually tend to sort of do within a matter of sort of about 2 to 3 sort of working days anyway, as a matter of course. So we could put, something on that if you wanted to say the results will be given within a time scale of a decision. I'm quite happy to sort of change that.
I just, there is 2 questions that need to be asked. That because we allow 21 days for appeal, in which case are we doing the decision that's made at the committee, or do we wait for the 21 days for the appeal period? I just think it needs further clarification in view of a challenge, really.
The notification in the letter that goes out actually gives the details of the right of appeal and the 21 days element of it anyway. With regards to, this is when decisions are made by the committee. There are legal time scales in place under the legislation anyway of how quickly we've got to sort of bring it to the committee as well when hearings have to be held. So that's why it's not put in the policy, because there are legal restraints which will be highlighted by letter. So I don't know if you want to put in how quickly would notify them after a decision.
What would you say is a reasonable time then?
Like I said, the norm, when we have a decision in committee, it would be usually within 3 working days, a letter would go out giving the results of that committee hearing and then giving them the 21-day option of appeal. So usually it is done within the 3 days. Okay. So I don't think there's any written down anywhere. As long as you give them notice within a reasonable time, it states in the Act itself.
We don't want to sort of shoot ourselves in the foot that if it's not done for any reason, it could be that that officer is, the next day goes on leave or whatever. But I just wondered if that we put in a time scale.
Yes, Chair. I agree with your sentiment. It is a bit open-ended there, and somebody looking at waiting to see how the decision was derived, etc. might think, well, how long do I have to wait, without having to contact somebody? So I think it would be reasonable to put in there with a target time of 3 days. Yeah, that leaves it open a little bit, I know, but at least it's telling people that, look, within 3 days, if you come back in 3 days' time, you should see something here. If not, there's something going on, but you don't want to shoot yourself in the foot in that sense. So I would say with a target time of 3 days to be displayed on the website or as soon as possible thereafter. Yeah, I propose that, Chair.
Jim, have you got a comment?
Yes, thanks, Madam Chairman. Yeah, that point, it says in 3.7 that it'll be posted on the Council's website as soon as possible. The point I want to make is an applicant or someone who's, an appellant, if you like, they give the decision on the day. So they know what the decision is, and it's a matter that is confirmed in writing, within a reasonable time thereafter.
I think it was where I was coming from is just that members of the public that may have not, they may have been following the licence or wanted to know what the answer was really, in which case if I think we need to be smarter of when our time scale is for them not to sort of complain. So.
Can I therefore second Councillor Frost's proposal, please?
Are we all in agreement? Yeah. Okay. And the other, sorry, my computer is playing up today and it's just gone dead when I've highlighted everything on there. In view of the licence objection, protecting the child from harm, we've moved forward in the word protection in regard to safeguarding. I'm just wondering if that is discussed in the forum and whether that word in protection is going to change in view of this document as it's been your wider authority changed.
The reason why is word is protection of children from harm is the actual wording in the Act itself.
Yeah.
So that's why it's remained as it stands.
All right. And the other point, and you have to excuse me because I haven't got it on the hard copy, is in view of training. It just says that members should receive training, and this has been much a debate within this committee as members sitting and not having training, or they've as there are changes that periodically happen and we're brought up to date, whether that again that we should have a minimum length of time for training, that we should record this in the document. As every chain, I think at least the last 3 training sessions that I've chaired, even if not more, members have been quite annoyed about the amount of attendance for the training sessions on the licensing or everything to do with this committee. And there are periodically changes to this Act and procedures, and I just wonder that whether we need to have a minimum period set for this and stated within the policy. Yeah.
I don't know what your views are on that, really. I don't know if we don't want to be restricting ourselves too much, saying you've got to have X amount of training, but perhaps if you could word it, say something like if there's changes in legislation, members will be notified and trained of those changes, perhaps something like that.
3.10, so I've found it here on the hard copy. 3.10 is of the policy. Did you have a comment?
Just that you would need to sit a bit straighter because you're not coming off on camera for people looking at you on webcasting.
Okay. Simon.
Yes, Chair. May I move now the document, if we're going to that position, to come back to us on the 21st of April 2015? Is that fine? Because this is only a draft document. The final draft then will come to us on the 21st with the amendments in, hopefully. But it will do the rounds with the other partners within the consortium, yes. Is that right?
That's right. If there's any responses from consultees within the 3 months period, that'll also be brought to this committee for your views on those responses and whether you want to include it or not include it within the actual document before it goes to full council.
Councillor Higginson?
Yeah, thank you, Madam Chairman. Just a quick point on that. Members, this committee and the planning are quasi-judicial committees. But there is a stipulation on planning, and I stand to be corrected on the planning committee, that if you were not trained on planning matters, then you couldn't sit on that particular committee. And I think the same thing should apply here, because particularly in relation to licensing, it can be very complex when you sit in. If you've got a subcommittee sitting and can be all day, and I've sat all day. You're in different arguments and points of law and that type of thing. For someone who is new to it, or could even be a new member, let's face facts, But I think, you know, it can be a daunting experience, and you need people who are trained and trained by the appropriate trainers, then, if you like, who have a lot of experience in this type of work. If you get them people to do it, and I think it's got to be done particularly at the start of every new council, because you never know what the you know, who's going to be sitting on what committee, particularly licensing, you know, on a new council. And I think it's important that we make the point, and it should be a council policy, that particularly for this committee, licensing, that any new members must be appropriately trained before they can sit. I think that's a necessity, given the legal issues that arise and you have to adjudicate on.
Thank you, Jim. This is my query, because I think people receive training, but maybe they don't, if they've sat a second term, they've not necessarily attended that second, that training that is offered for everybody. So you've got some of the new members, and a disproportionate amount of the older members, and that's why I think maybe it needs to be stipulated that every term that they need full training, so that, you know, we get the updates, everybody gets the updates. It helps that newer members. It's a big policy. It is a quasi-judicial committee, and I just think, you know, maybe that we should put that every term, every councillor's term, that they should receive the full training.
I could just come back on it, yeah, and recorded as well as to who was being trained.
In the past, we've looked at this, and it's not been in the Constitution, but if we have it, it can, you know, we could put it in within the licensing policy.
Thank you, Chair. I have some sympathy with my colleague because it's good to have an appreciation of how the machinery works. But in this council, we have the officers who are the experts, yeah? They're the ones that are day-to-day dealing, they know the rules, regs, etc. And we, as members, represent the community, you know, and we bring the extra bit of the community awareness to it and say, well, hang on, is this fair for our community? That might be the law, but do we need to change the law or whatever? Yeah. So to that end, I'm a bit nervous of saying you cannot sit on the licensing committee if you haven't been trained, because I think that goes against that philosophy. I think what would be useful is to say that training is desirable, so that you can have a better appreciation of the way it works and what the law means. So I think it's desirable. But I would stop at saying it's mandatory, to be honest with you, because I wouldn't want to stop anybody attending this licensing for the first time. They're a brand new councillor, and, you know, yes, they've got every right to sit in this committee and to pass a comment. So I sympathise to a certain degree that, yes, you need training to appreciate how it works and what your responsibilities are. But I would stop at making it mandatory as the planning one. That's just my personal comment.
I just want to make the comment on that, and it's remiss of me not to mention, I appreciate the comments that Councillor Prosser made. The point I'm getting to, and I should have said it earlier, I suppose, is when we have an appellant coming here to, you know, because they're in problems of one sort or another, then there should be, members should be trained on that particular along those particular lines, accepting, of course, that licensing is a fairly general thing. But I think before anyone comes to sit on the subcommittee, as we do, when it's only 3 members, then they need training before they sit on them. That's the point. And I should have mentioned it before. I'm sorry for that.
Okay. What the Councillor Webb?
Is there anywhere some record? And I did do training definitely when I first came on this committee, which is quite some time ago now. But I mean, is there any record of who's done what, and you know, is there any chart to show where we are? But I agree with Councillor Prosser really as well. And also, we haven't been asked to actually agree the recommendations, have we? Or this document, we've just been asked to consider the proposals. And if that's what Councillor House was recommending, I would second that. Thank you.
We're considering the proposals, but we're also making comment on it for it to come back. So what do you want to do with this line 3.10? Council will ensure that members and relevant officers are appropriately trained to carry out their duties under the Act. Just leave it as it is. Do you want that? Like, leave it as is. Okay. Councillor Howard, did you want to speak?
It was just on Councillor Higginson's point there. He does have a valid point with the subcommittees, and I think we'll use our discretion there. If a subcommittee does sit, it has to have the training there, and the subcommittee's 3, and we know who the 3 are, and if one has to drop out from there, we will make sure that if somebody takes that seat over, I think just use your discretion on it. It doesn't make it too complicated, and make sure that we've got the width, the constitution's changed and all them things. I think we're just trying to make a rod for our own back really with it all.
That wasn't an agreed subcommittee. I think the licensing officer used to call upon us when we were free. It wasn't in stone, really, was it, Linda? If there was, you used to phone round and say, are you 3 available for a certain day? And that's how it worked. It wasn't actually in stone, the 3 on the subcommittee.
No, the subcommittee, yeah.
No, the actual law states as long as there's 3 from the main sort of licence and regulatory committee.
No. Okay.
Through the chair, I move progress
Yes,
on
yeah.
Simon Haworth's, Councillor Simon Haworth's motion.
If there's no other clarification needed or any further comments, then you're happy to move this report?
Yeah, proposal we
Propose.
accept this.
Okay.
The comments have been made, Madam Chair.
Subject to the comments has been...
Okay. And then the next agenda is the addition of agenda regarding mobile homes. And I think, Hugh, you're going to present this.
Thank you, Chair. Apologies for the late circulation of the papers, and thank you for including them in the agenda. A number of reasons, members, today for bringing the report before committee. Firstly, to bring to the attention of members of the Mobile Homes Wales Act 2013, and the key issues of which are outlined in points 3.1 and 3.2 of the paper. Basically, the main aim of the Mobile Homes Wales Act is to better protect the rights of people living in mobile homes or the permanent residential caravan sites, which are more commonly known as. And the paper introduces the responsibilities it places on the Council, which are set out in point 3.3 of the paper. We have 2 permanent residential sites of medium size in Monmouthshire at the moment, and 1 or possibly 2 sites of 2 or less vans, which could also fall into this category of mobile homes. Secondly, the purpose of the report is to bring to the attention of members a number of matters that need to be addressed so that we can implement the responsibilities of the Act. If the Chair permits, I will go through these matters and take a guide as to whether members wish to discuss and raise any points after each point, or once I've provided a summary of the whole. So point 3.6 of the report introduces the first matter. The report proposes a recommendation to be made to the next meeting of Council that the authority to issue, vary or withdraw a licence is best delegated to the L&R Committee. If this is agreed by L&R now, and the delegated authority subsequently agreed by Council, it's our intention to bring the matter back to this committee to agree the detail of that delegated authority. For example, whether or not licences are to be issued by the authorised officer following consultation with the appropriate member, or whether the authority to issue licences, vary, revoke, is to lie solely with L&R. But that would be addressed in a subsequent report. The second matter is that the Act introduces a fit and proper person test for the managers of a site. Again, this report proposes a recommendation to be made to the next meeting of Council that the agreement for the detail of a fit and proper person policy is best put before this committee. If this is agreed here and subsequently agreed by Council, the matter again to be brought back to LNR for the detail of the appropriate fit and proper person test to be agreed, including where the authority lies for deciding compliance, whether or not it's with the individual officers where there are no issues, for example, or with the committee where there may be issues raised. 3.7 of the report provides the third point, which we're looking for agreement. As provided in 3.7, the Act enables the local authority to recover the costs reasonably incurred in licensing the sites, inspecting them, etc. Before a local authority can charge a fees policy must be published. I'm advised that a fees policy needs to be agreed by Council, but prior to reporting to Council, we're looking for the basic principles of a fees policy to be agreed by this committee. These are provided in detail in Appendix 3, but can be summarised as follows. Firstly, that a charge to be made on a cost recovery basis only, which will be comprised of a flat fee for the processing of the inspection, and secondly, a fee per mobile home pitch, so that the time spent by officers inspecting on site will be proportional to the fee charged. The second principle is that fees are to be only charged for those licences where sites operate for commercial gain and comprise more than 2 pitches. This is to reflect that sites of just 1 or 2 pitches require relatively little input from the officers. And the third basic principle is the applications for varying a site licence will just be the flat fee processing the application and not the inspection fee per pitch. That's where applications are made to vary an existing licence. Finally, with respect to the report to Council, it will request that the authority be delegated to LNR to agree any future variations of a fees policy once agreed. Finally, as provided in 3.7, the Act enables charges to be applied for new enforcement powers which are to be introduced by the Act. These charges do not need to be published in a fees policy, but the proposals are set out in Appendix 3 for common consideration if a member so wish.
Councillor Webb, then Councillor Higginson.
Just one thing that's occurred to me, Chairman. Over half this committee are on planning. Does it incur any confusion with planning, please? Perhaps our legal advisor would help us there.
I don't think that would have any this is entirely a concerned area.
Councillor Higginson.
Yeah, thank you, Madam Chair. Licensing is one thing, and planning on a site is another thing. I have to say, I'm really pleased that this has come forward for us to, because we know that in different, certainly in certain areas, there are issues with caravan site owners, particularly residential site owners, where they try to impose conditions upon the owners of homes as to what they can do and not do, particularly in view, if they want to sell and move on. And it certainly applies with holiday sites as well. And I mean, the officer might want to make a comment on that. But I mean, when I don't have a van anymore. But when I had a van first, I could sell that van. It wasn't a residential site, but I could sell that van to anyone I wanted to. And there was no problems. The site changed hands, and then there was restrictions put on, and they were imposed. There was no consultation whatsoever. So yeah, from the comments I made, and I'm just pleased that we got something we can nail down. And there are sites. I mean, there's a site within about 1.5 miles of where I live, which is one a residential home on it. But it looks like a brand spanking new bungalow, to be quite honest about it. But it is nevertheless a very nice mobile home, I have to say. So I mean, I don't have any comment to make about them, but I just outlining the fact that there are some nice ones about, and there are some places where they need looking at and possibly updated.
Councillor Edwards.
Just to see if there's any clarity with the planning issue. As I chair the planning committee, I believe if you want a mobile home to sort of live in your garden or whatever, you'd have to have planning permission, and it usually has to be very carefully considered, and it's usually on a duration of no more than 3 years is appropriate, but it doesn't require a licence to do so. So I think it's a separate issue completely to this committee.
Councillor Prosser.
Yes, Chair. I'm in agreement with the policy as displayed. There's only one little area I'd like clarification, and it says about the fees. I'm looking at 2.2 of the appendix, and it says a flat application fee to be determined in report to council, and fee per pitch to be determined in report to council, and a licence is granted for up to 5 years. Now, obviously, wages go up annually, so cost of recovery, you could argue, goes up annually. So should fees go up annually or not? So, but when it says granted for 5 years, so what I'm minded to say there, should that be determined in report to council annually? Or is it every 5 years? Or in between? Could I have clarification on that,
perhaps
please?
I can answer. I know it's obviously not my report, but with regards to the fees with all licensing matters, as you recall, we did a major revamp on fees, doing cost recovery exercise, and it's quite an in-depth sort of spreadsheet which looks at wages for the previous year, and it has to be reviewed every year. So that'll be the same. That will fall into the same category.
So it is annual, Chair, is what you're saying. So whether we could put in report to council annually, I'm just trying to, dot the I's and cross the T's, as they say. Thank you.
The other question that I was going to ask, in view of the sites that are present, they will have to fall in line and apply for their licence, or will this only take effect for new sites?
Thank you, Chair. All the existing sites that we've got are licensed at the moment under the Caravan Sites Act 1960. This introduces a new licensing regime, and all existing sites will need to be issued with a new licence. So all existing sites will have to apply for a new licence so that they come under the new licensing regime. And most importantly, the permanent residential caravan holders are protected by this new legislation.
Okay, thank you. Is there any further questions?
Move the recommendation, Madam Chairman.
Okay. We've got a seconder for that?
I second, yeah.
Okay. Or show hands. Thank you. The report will now go to full council. And just to note, the date and time of the next licensing committee will be on the 10th of March at 10 o'clock. Thank you for your attendance.